found that Lattimore was traveling with $20,000 in cash for possible art purchases, but by the time she arrived in Tucson, she didn't have that cash. That's because a federal drug enforcement agent had seized the money. Here's the catch. Lattimore was never arrested and never charged with a crime. Civil asset forfeiture, often referred to as legalized bounty hunting, is currently making a mockery of our rights enshrined in the Constitution. This is why we stand that the United States federal court system should be significantly reformed. To provide clarity for the round, let's define civil asset forfeiture. Civil asset forfeiture is defined by George Lee as a J.D. wrote, quote, "What civil asset forfeiture amounts to is seizing property from someone on suspicion that it was in some way connected with a crime. The individual need not ever be convicted or even charged, but won't get the property back without going through legal procedures," unquote. But how often does this happen? Let's look at the facts. Fact 1, civil asset forfeiture used rampantly on federal level. Civil asset forfeiture used rampantly on federal level. John Malcolm, a graduate of Harvard Law School, wrote in April 2015, quote, "The amounts of money involved in forfeiture cases are huge and have grown exponentially. Many federal agencies participate in forfeiture programs, including the ATF, the DEA, the FBI, the IRS, the IC, the CBP, and others. In 2012, the value of seized assets had grown to $4.3 billion, unquote. Seizing property may be justified if seizure punishes crime, but we see in fact too, convictions do not follow forfeiture. Convictions do not follow forfeiture. The Economist reported in 2014, quote, "Civil asset forfeiture does not require criminal conviction or even a criminal charge. In fact, a study found that 80% of individuals whose property was seized by the federal government were never charged with a crime," unquote. In the words of Congressman Sensenbrenner, "It is hard to believe that this can happen in America. The government is seizing billions of dollars from Americans, often without even charging them with a crime." To align the court system with the constitutional intent of punishing the convicted, we provide the following goal. Tough on crime, yet steadfast in justice. Tough on crime, yet steadfast in justice. In the pursuit of fighting crime, the government must abide by constitutional boundaries. We uphold our goal by restoring the concept of due process of law. Due process of law is defined by the Oxford Dictionary as the fair treatment through the normal judicial system. The Constitution clearly states in the 14th and 5th Amendment that no person shall be deprived of life, liberty, or property without due process of law. Unfortunately, the courts are not providing Americans with these protections. Let's break down the current system failures in the harms. Harm 1. Legal counsel is not provided. Legal counsel is not provided. The Heritage Foundation stated in 2015, quote, "Civil forfeiture proceedings do not carry many of the basic legal protections Americans expect in their justice system. Legal representation." No such rights exist in civil forfeiture proceedings. Property owners must pay for their own lawyers at expenses that often exceed the value of what has been seized, unquote. One civil asset forfeiture case involved a DEA agent seizing a man's airplane. The man fought the seizure in court, proved his innocence, and got his airplane back. However, this man spent $85,000 in legal fees, which he raised by selling 3 other airplanes. Unlike this man, most people don't go that far. Suppose a police officer seized $10,000 from your wallet. Would you spend $20,000 in court fees to get it back? Of course not. Injustice is usually overlooked, and most forfeitures go uncontested. This brings us to harm 2, low standard of evidence. Low standard of evidence. In the same article above, the Heritage Foundation continued, quote, "Unlike in criminal cases where the burden is beyond a reasonable doubt, in civil forfeiture proceedings, property owners, in most jurisdictions, the government need only show that property was subject to forfeiture by preponderance of the evidence, a much lower burden. And to seize property in the first place, the burden is lower still, mere probable cause. The bottom line is, it is easy for property owners to get pulled into the forfeiture system, yet incredibly hard for them to escape it." As Alan Brownfield reported in 2014, that, quote, "If law enforcement officials believe that cars, property, homes, or especially cash is connected to criminal activity, they can take it. But officers' pretexts can be shockingly thin. Cars that have tinted windows, cars that are too clean, cars that are too dirty, drivers who are too nervous, the presence of energy drinks, and so forth. The standard in the current system is too low." Let's move on to harm 3, constitutional protections ignored. Constitutional protections ignored. Congressman Jim Sensenbrenner put it in February 2015, quote, "The right to own property is enshrined in the Fifth Amendment to the United States Constitution. Current forfeiture provisions mock the spirit and the meaning of that passage and create serious issues under several other constitutional provisions. It is no wonder my former colleague described civil asset forfeiture as an unrelenting government assault on property rights fueled by the dangerous mentality that sanctions shredding the United States Constitution into meaningless confetti," unquote. The preservation of our constitutional rights demands that the federal court system be reformed. That's why we propose the following plan. Mandate 1. Require judicial hearings. Require judicial hearings. All federal asset forfeiture cases must be brought to federal court. A probable cause hearing must be held within 30 days of a civil asset forfeiture seizure. Unless the property owner is convicted beyond a reasonable doubt, seized property will be returned. Any proposed settlement will be reviewed and decided through court processes, not by an administrative agency or through police bartering. Exceptions include if the defendant is deceased, unknown, a foreign fugitive, or an alien convicted of a foreign crime. Mandate 2. Public defenders. Public defenders. The federal courts will provide counsel to property owners in civil asset forfeiture cases. 80 public defenders and support staff will be hired for civil asset forfeiture cases. Mandate 3. Raise the burden of proof. Raise the burden of proof. The courts will raise the standard to require demonstration that the property was subject to forfeiture by clear and convincing evidence, a standard significantly higher than the current preponderance of the evidence. The burden will be on the prosecutor to demonstrate that the owner knew their property was being used in the commission of a crime. Agency and enforcement, the United States federal courts, the U.S. government, and any other necessary government agencies to pass and enforce that plan. Funded. The proceedings of all federal civil asset forfeiture will go towards a fund that will finance Mandate 2's provision of public defenders and costs incurred with increased judicial caseload. An additional funding for startup costs will be apportioned through normal budgetary means. Civil asset forfeiture is an essential tool, but even in the government's fight to be tough on crime, it must abide by constitutional boundaries. As Alan Brownfield stated, quote, "It is time that all citizens' Fourth Amendment rights are protected. When it comes to the confiscation of property, the burden should be upon those doing the confiscation. And if citizens are deprived of their property without any legal basis, they should be reimbursed for any legal fees incurred in getting their property back. This is only fair." With the affirmative team's plan, the federal courts are required to take action. Legal counsel will be provided, and hearings must be held after a person's property is seized. As Lance Lemons wrote in August 2015, quote, "More and better safeguards need to be in place at the federal level to protect property owners who haven't committed any crimes. The right of due process is a sacred right that our founders held dear, and one that a just and fair legal system should always look to uphold. The Constitution demands no less." Thank you very much.
Ready?
I sure am.
Hey John, how are you doing today?
I'm doing pretty well. How about yourself?
I'm doing really well. I was wondering if I could see a copy of your one.
Of course.
Is it okay if I hand this to my partners? Awesome. Thank you. I was also wondering, what is the purpose of civil asset forfeiture?
Sure, the purpose of civil asset forfeiture was to fight crime and to stop criminals.
Okay.
But the current system has skewed it and is now being used against innocent
So then the purpose of is to deter and to punish crime then?
Sure, the purpose was that, but as we've shown through stats and studies, it's gone horribly wrong.
Okay, but on that issue though, how many cases are actually contested and how many are uncontested?
Sure, 20% of cases are contested.
20% of cases are
Yes.
contested. So you would agree that usually an innocent person will contest a case while a guilty person would not?
No, as we showed in our harm 2, people don't contest because the legal fees. The legal fees are more expensive than the property actually taken.
But you would agree that
so
there
they don't
is a
contest.
safeguard for the innocent people by being able to contest a civil asset forfeiture?
We'd have to see evidence under that.
Okay, thank you. And also, when you would agree that the U.S. Code says that property cannot be seized without the owner of the property knowing?
Sure. The person would know that their car is missing.
Okay, so then they're aware of they're seizing them.
Yes, the owner would know that their property is taken.
Okay, and would you also agree that the Supreme Court has ruled in the past that civil asset forfeiture does not violate due process?
I would also disagree because the Supreme Court has had multiple rulings on civil asset forfeiture and they've all had different results.
Okay, thank you. And I was also wondering, you would agree that it was established a long time ago that the government, as you even mentioned, you want to see that the prosecutor and the government has the burden to prove probable cause before they can seize?
Yes, but as we pointed out, probable cause is too low of a standard.
Okay, and is there any sort of protections at all in the system?
In the system, I'm not exactly
for
sure.
innocent people.
For innocent people. I mean, they have the ability to go to court if that's what you're wondering.
Okay, so but they don't go to court just because of the fees.
No, the affirmative team said the reason why they don't go to the court is because of the legal fees and the standard of evidence.
Okay, thank you very much.
Sure.